Is okay. First, let's just kind of give an overall 30,000 bird's eye view of what is workers' comp law.
Well, a workers' comp arises out of an injury on the job. So if you're working and you get injured while performing the duties that are required of you, then oftentimes that would be considered what we call a on-the-job injury or a workers' compensation claim. And it's kind of funny because a lot of people think they're actually suing their employer, which is not really the case. We are required, employers with more than 4 employees are required to carry workers' comp insurance. And it's literally an insurance claim, and you're filing a claim against your employer's workers' comp insurance company. And so if you've been injured on the job, you have an injury that arises out of and in the course and scope of your employment, then it would be compensable. That's the definition. And there's, an injury does not have to occur literally at one particular time. There doesn't have to be a specific event. And in fact, I had the opportunity back in '98 to try a case in front of the Supreme Court in South Carolina that reiterated and affirmed that the position in South Carolina is that injury by accident does not necessarily mean there has to be a specific event, that the injury could occur over time. And that case involved a forklift, and somebody tried the case before I got the case, and we lost on causation, but the Supreme Court agreed with our position. So injury by accident is an unexpected result because of some work activity. So it needs to arise out of and in the course and scope of your employment. So just because you have a heart attack while at work doesn't mean you have a workers' compensation claim. So there has to be an injury that is the result of some type of work activity, and the injury needs to be caused by it. So it needs to be most probably, within a reasonable degree of medical certainty, caused by that particular work activity. So,
Okay.
and there's all types of injuries.